Okay, so I officially hit record. We have a lot to talk about today, guys. I am pumped though, because one, we're live and I missed y'all. And two, I had something funny to tell y'all really quick. So y'all know, or I think I told y'all, pretty sure I did, that I'm the advisor to the Cat Club. And I've added two more clubs under my belt this last week because I can't say no. That's my fault. My downfall is I can never say no. I am now the advisor to the A&M Bowling Club. Now, if you ask me, do I bowl? No, but I'm going to. And also, again, the motorcycle club. So I have all these random clubs that I adore the students, but it'll be interesting. But this last weekend, I got a call from A&M and somebody dumped a bunch of cats on campus, right? It happens all the time. And one of the kids was like, there's this cat with kittens, can you help me with them? They're really sweet. So I'm like, yeah, sure. So I show up and I have my little carrier and she hands me this cage and she's like, here's the cat. And it's like Jurassic Park, guys. It has like a towel over it. Like it's like kind of rocking. And I'm like, is that the cat with kittens? And she says, oh no, this is the other cat. And I'm like, why can't I have a cute cat with kittens? And she's like, oh no, somebody already fostering that. And she's like, this is the other one. And I'm like, of course I get the other one. And so I'm like, is it feral? And she's like, oh no, it just needs love. Guys, come on. So I'm sitting there and I said, well, you lift the towel so I can see like, what its state is? And she's like, oh, you don't want to do that. I'm like, well, why don't I want to do that? She said, well, it hisses a lot. And I'm like, again, is it feral? And she keeps on saying, no, no, it's just really scared. So I'm like, all right. So I get in my car and I had transferred, we had like done this like shimmying to where I have like a cloth, again, not my brightest moment, guys. This kennel carrier, right? Because we had to transfer it. So she'd opened the side hatch and we'd pushed it into the other one, right? And again, like Jurassic Park, it's just like rocking and I feel like I should be smoking a cigarette like Samuel L. Jackson. Like it was a lot. So I put it in the car. This is when it gets really bad, guys. I didn't realize my damn carrier had a hole in it. Okay. So I'm driving and I see in my rearview mirror, it's like a ping pong fur ball. It's just like pew, pew, pew. And I'm like, oh my God. And I pull over and yeah, the cat got out. And remember that question I asked? Is it feral? Yeah, the answer is definitely yes. So I had a feral, angry cat ping-ponging in my car. And you know what I had to do at that point, right, guys? Anybody want to guess? No guesses? Let me see if anybody in the chat guessed. Yeah, that's exactly right. I had to just open the door and it was just like, phew. And that was that. That was the end of that. But yeah, it was a very exciting moment, a very scary moment. I really thought I was going to get mauled in my car. And I was like, this would be fitting for the end of my days. My tombstone would read like, yeah, that checks. Yeah, that's exactly right, Ignacio. That's exactly what I did. Let it out. So that's my exciting story, guys. So if somebody tells you that they have a cat that you need to rescue and you ask them, is it feral? And they respond, it just needs love, don't do it. That's the moral of that story. So, okay, without further ado, this week is, I always say this, but I really do mean it. This week is a really great week, but before I get into it, and I'm not done grading, I'm so sorry. I'm trying my best, but I want to emphasize, and I hope you guys don't get annoyed with me. I really do like to thoroughly review all of your work, because I want to tell you again what you're doing wrong, if anything, and what you're doing right. But I did see a theme this week and it bummed me out because quite a few of you didn't cite any case law. Remember, case law is your best friend. You're always going to have case law. And I'm going to say that again. You're always going to have case law. Again, wouldn't it be weird if like you called the plumber and they showed up and they didn't have any tools and you're like, "How are you going to fix my commode?" And they're like, "I'll do it, trust me." And you're like, "That's weird." Right? So think of it like that. You're going to have your tools and your greatest tool, your wrench, so to speak, is case law. So I didn't ding too many points for that because, again, these are just discussions, right? But I do want you guys to constantly have that in your head as to how and what cases, because it doesn't have to be more than one case. You might say, you know what, I think this one case fits perfectly, and you might be right. Okay. So, with that being said, just make sure you have one in there. Okay. It has to be in there. And also, again, try to avoid first person. Instead of saying, I believe that blah 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 blah, just state your belief. You don't have to preface it. I know it's your belief because you're writing it, right? So there's no reason to preface it. That wastes word space and it detracts. It honestly weakens your statement. So be more confident, avoid that first person, and use case law. Okay, that should be again an anthem in your head week to week to week. So make sure that you do that because I have, and again, I'm not done yet. I think I've gotten two and a half of the sections done. So I have I have my homework today, guys, but I have my coffee. So I have my coffee, no feral cats, and I'm ready to rock and roll today with grading. So you should, by the end of today, see a grade if you haven't already. And that's exactly right, Billy. Yep, Billy got the type of bird correct. That is exactly right. It's one of my favorites. It's just such a cool bird. All right. All right. So this week, you guys
It's
have
my
some,
favorite too.
isn't it great? It's just an amazing bird. It almost
I
looks
love
to
the
me like a
sound.
Jim Henson puppet. You know what I mean? Because the way it walks, it's just it's just a heavy bird.
Yeah, I love the sound of it.
Mm-hmm. For
Sounds
sure.
like a machine gun.
Yeah, yeah. Oh, that's true. I didn't think about that. That's true. Yeah, on a random note, I didn't rescue the feral cat, but my husband, he actually did rescue a barn owl over the weekend because it had eaten a rat that somebody had poisoned. Somebody had put rat poison out, and the poor owl had eaten it. And poor thing, it was in bad shape, but we think it's gonna pull through. So he was able to do something good. I just let the damn thing out. So two totally completely different outcomes of rescued animals over the weekend. He did a better job than I did. But the cases this week are awesome. I say that every week, but I really do mean it. These cases, the history, the context, I hope you enjoy reading them. But I'm going to try to bring to life some of the context that is perhaps not as strongly presented as I would have hoped in the writing, the opinions that I think will kind of bring home the concepts that you need to know, that you need to understand in order to successfully tackle this week's writing assignment. Okay. So you have Brown v. Board this week, you have Griswold, excuse me, you have Glucksberg, you have Loving v. Virginia, you have Roe v. Wade, and of course now you have Dobbs. Now what's crazy, it was when Dr. Helgi and I were first, well, not when we first, but toward the beginning when we were teaching together, that decision came out the week that we were teaching Roe v. Wade. And we were just like, man, now like it was just like a firestorm in terms of everything. We had to change our this section of the class and it was in real time. So it was bonkers that term. But now we have a better grasp on it. So we'll walk through it together in terms of its impact, what it means, all that fun stuff. And then what did I put on the bottom? My head's, oh, and how it overturned. Okay. But I want to first do my weekly spotlight. Now, I want to preface something. One of you emailed me and made a really good point that I haven't highlighted week 3, the writing assignment. And that's in large part because Dr. Helgi grades that. So I'm going to change that. I haven't changed it with this weekly spotlight because I'm doing this week, right? This last week, week 4. But I'm going back in addition to this week grading today, and I'm gonna pick out from week 3 some highlighted submissions that I see that Dr. Helgi graded. And when we come back next week, I'm going to highlight some long written assignments submissions from week 3 and week 5. Because I think that's a fair point. You guys should be highlighted for your good work in the long written assignments as well, even if I don't grade those. So, good suggestion. I appreciate that. But I am going to highlight for this week, first and foremost, Billy. And I'm sorry, I put Bill. It's Billy. Billy Webb, a fantastic submission. I'd like everybody to see, and let me move my face so that way you can see this. There's a couple things I want to highlight from Billy's submission. First and foremost, case law. You see it up front and center. Not only does he utilize Federalist 78, but he utilizes the Walter Nixon case and Youngstown and Trump v. Hawaii. But there's also something else I want to highlight. He is not just citing the names, which some of you were doing. Some of you are just throwing case names into your post without giving it any context. Billy takes it a step further. So not only is he citing Federalist 78, but he's saying why he's using Federalist 78. Not only is he citing Walter Nixon, but he's saying why he's citing Walter Nixon. So he's giving context to the cases that he's incorporating. So I want everybody to give long distance applause, high five to Billy Webb for an amazing submission, which is very good. A plus on that. The second one is to Mr. Ruben Pena. And as you can see, he used IRAC. I wanted to highlight his because I feel like the IRAC writers don't get enough love. And I wanted to make sure that you guys know that you have this option. So if you guys like this type of structure, absolutely use it, okay? So you can write in this format, and he did so in a beautiful way. So he wrote his issue between the legislative, executive, and judiciary, which branch is the most powerful? So again, the issue is the million-dollar question facing you, the writer, or the United States Supreme Court. And in his rule, he cites what? Case law. So that made my day. And then he applies it. And then he comes to his conclusion. So this is just a beautiful example of not only IRAC, but also case law usage. So I really want to give Ruben a long distance high five as well. And good job. And he's also getting long distance high fives in the chat. So awesome job, Ruben. And then Sarah. Sarah did a phenomenal job as well. I loved how she also uses Federalist 78 right out of the gate. So right out of the gate, you see her use Federalist 78. And then if you follow down through her analysis, she also cites Article 1, Section 8. So you see constitutional incorporation there as well. And then you also see Nixon and the steel seizure case. So there is a buffet of references in Sarah's submission that supports her position. So beautiful submission, Sarah. Great job. And Tommy likewise. You see case law right at the top. Look at that. He states first and foremost his position, and it's so beautiful and concise. He starts out, the executive is the most powerful branch. Boom. It's like mic drop, right? And then following that, he uses case law in the subsequent sentence, and Youngstown Sheet and Tube Company v. Sawyer, presidential power stretched until, and then he gives more case law to further support his position. So again, I love this in particular because if you look at his very last sentence, he concludes it in this beautiful way that puts a bow on his position. These examples reveal dominant executive influence. Again, it's just another way to state his position, but in a strong conclusory manner. So beautiful job, Tommy. And so with that being said, there we go. With that being said, I know you guys have maybe not all of you, but maybe some of you have reviewed the assignment for this week, week 5, and you may be feeling a little nervous. And I don't want you to feel nervous because again, think about everything you've done up to now. Time flies, right? It's crazy. We're already in week 5. It blows my mind how this class, it just is like blink, done, right? But I really want to emphasize that you guys have these tools, and I really hope that you all are keeping a Microsoft Word or whatever documents platform you use to keep a running list of the cases that we go through with like a short summary of what each case is about. Because that'll help you as you tackle these writing assignments to look back at your list and say, oh, this case will help me. And what I sincerely think you should do is print out that list every time you have a writing assignment. And as you read the hypothetical, turn to your list and check mark what cases you think might help. And then try to draft an outline of your answer. This will kind of keep you in your lane, right? Instead of tackling it and writing it as you think, which is not a good idea because our brains have a nasty habit of going off track, right? So keep in your lane, choose the cases that you think will help you before you put pen to paper, before you put fingertip to keypad, and then draft an outline and then draft your submission. Just a friendly advice. But if you have your own method, then that's great too. But the assignment asks you to do the following. You're working for this judge, and she's trying to determine whether the above facts, and it's long, so I didn't include the entire thing because it's a long set of facts. Establish that Charlie has a fundamental right to access medical care or use medical marijuana. She's not certain yet how to frame this potential fundamental right, and I want you guys to really cue in on that word. Because she is very busy, she doesn't want your answer to exceed 400 words. And guys, that is very realistic. She would like your clear and succinct advice on this important constitutional question. She's a highly respected judge and does not want to see her decision reversed on appeal. Okay, so this is your time to shine. Now, again, remember, avoid first person. I would not start out your submission by saying, I would advise Judge Boyle. No, because guess what? You've already wasted a ton of words. Just tell Judge Boyle what you advise, right? That it is or is not a fundamental right. That's a great way to start. Hint, hint, hint. Now, with that being said, Brian asked a question. He said, the case says, if will be a declaratory judgment. Is this important versus some other type of judgment? No, I would not pay that any heed for right now. I would focus more, and I really want you like a bird dog, okay? I want you guys to focus like zero in on that fundamental right concept. And we're going to explore that in great detail today, okay? So you guys are going to be ninjas and fundamental rights by the end of today's session, I promise, okay? So you remember my motto. Do y'all remember my motto? And I'm going to drink some coffee as I ask y'all that. Do y'all remember? Yes, exactly. Thank you, Caitlin. Thank you, Michael. That's exactly right. Keep it simple, silly. So, this area of law, to law students in particular, is probably one of the hardest. And as you study it, you're probably going to feel a little bit like Scooby-Doo. You're probably going to be like, "Rawr, like what?" I'm going to do my best in simplifying it. And I think, not to toot my own horn, but I think I do a decent job. But if I don't, if I say anything that is unclear, please let me know, okay? You won't hurt my feelings. In fact, I welcome the questions. With that being said, it is 9:18. I'm going to do my best to stay as close to 10 o'clock as I humanly can. But if I go a little bit over, please don't beat me up, okay? So I'll try my best. But if you need to hop off because of work or something, please feel free to do so. You won't hurt my feelings. Okay, so let me move my face. All right, so now we're ready to dig in. I'm super pumped. So much fun stuff. All right, so first and foremost, some things to recognize. Before we get into Brown v. Board of Education, there's a whole lot of context to take into consideration because there's case law that Brown v. Board of Education cites to that I think it's important to understand what those prior cases mean and where they come from because it gives you a better understanding of where the court's mind is, okay? So on April 9th, 1865, Civil War ended, right? So we're going a little bit far back. And then just a few months thereafter, December 6th, 1865, something was ratified. Anybody know what it was? Don't Google it. Anybody know off the top of your head?
14th Amendment.
Mm-hmm. Good. Let me see if the chat did. Not the Constitution, but yes, Dan, that's exactly right. Exactly. So the 13th Amendment abolished slavery, right? So yay, that's great. We're all rooting for that. So, but that's not the end of the story, right? I think we all know that's not like the end, everything's beautiful, right? If only. It wasn't until July 9th, 1868, so a few years later, that the following amendment was ratified. Excuse me, which was the 14th Amendment. Now, the 14th Amendment, this kind of changed the landscape in terms of federalism. Now, you guys know the 10th Amendment. We dove deep into the 10th Amendment, which said if the federal government hasn't been given a responsibility, an enumerated responsibility, then it falls to the states, right? But the 14th Amendment is the amendment that said, look, we're now going to add a word to a concept that's so important to our democracy that it's not in our Constitution once, it's in it twice. What concept is in our United States Constitution twice? Anybody know?
Due process.
That's exactly right, Christina. High five. That's exactly right. Due process, which says the government can't take away your life, your liberty, or your property without due process of law. That's in the Fifth Amendment and in the 14th. But they added one word in the 14th Amendment that changed things. They added, well, two words technically. They said no state can take away a person's life, liberty, or property without due process of law. So what that essentially was doing was giving the federal government the ability to rope in the states. So essentially, and let me move my face so you can see this, because I think this is a good visual. After the Civil War, the South wasn't happy, right? They weren't happy campers and they weren't falling in line immediately. Again, it wasn't like rainbows and happiness right afterward. And so, in order to get them to comply with equal protection and the different facets which thereafter followed, they had to rope in the states. Now, this is known as selective incorporation. And let me put it another way. Selective incorporation is the leash that you put on, let's say this cat, right? This cat, which obviously is so happy. So you put the leash on the cat, and even if you have to drag it, it's still going to have to follow you, right? So that is what the 14th Amendment due process clause is doing. It's taking that leash and roping in the states and saying, you Texas, you Louisiana, you California, whatever state it is, you have to comply to. You have to fall in line too, right? Because remember, the original Bill of Rights did not apply to the states. They only applied to the federal government because our founding fathers, they weren't concerned with state action. They were concerned with federal action because they had this ghost, right? Where they were saying, oh gosh, we do not want another monarchy. We don't want that to happen again. And so this is the first time that they were like, we got to worry about state action too, right? This is the first time that we're dealing with that. Now, right. Billy in the chat, Billy said all you had to do is put a leash on the cat this weekend. God, I can't even imagine putting a leash on that thing. If I would have done that, guys, I would have looked like I was in a battle. I would have been like all bandaged up, probably missing an eye or something. It would not have been pretty. I can only imagine. Um, so that is what the 14th Amendment is essentially doing here. So we have this beautiful 14th Amendment, which of course is, and yes, I would also be in the hospital for sure. We have this beautiful 14th Amendment, which is still alive and well, right? But is that the end of the story? Of course not, because that would be too easy, right? So let me give you a little more background. There was something that came right before the 14th Amendment, which is often overlooked and so cool historically that something like this existed. And some of you may not be aware that it did exist. I didn't know it existed until law school, and it blew my mind when I learned about it. So maybe it'll blow your mind. But before the 14th Amendment, there was actually a Civil Rights Act. Did you guys know this? In 1866. And it actually gave teeth to the 14th Amendment because it declared all persons, and listen to what it's saying, all persons born in the United States to be citizens without distinction of race or color or previous condition of slavery or involuntary servitude has rights. Isn't that amazing? So it is the tiger, so to speak, that's giving teeth to the 14th, right? That you have to respect people's rights, no matter their race. And this is, again, right after the Civil War, guys. So it's a big deal. And Billy said he knew about it because his wife's a history teacher. See, that's cool. That's amazing. I feel like a lot of this is just kind of tossed to the wayside in terms of classroom lessons because I know for a fact I was never taught this, and I think it should be because it's just an amazing part of history that is often overlooked. And it gives foundation. It gives, and you'll understand here in a second, it gives better foundation to understanding the following case. So the southern states were, of course, they were not happy campers, right? Because they're just not really jazzed about this situation. And unfortunately, in 1877, there was a compromise. And the compromise was that the Union troops were withdrawn from the South, right? And they were originally there to make sure that the South was doing what they needed to do to comply with the 1866 Civil Rights Act and the 14th. But again, to calm things down, they withdrew the Union troops, right, from the South, and it allowed something really nasty to fester, right? Now, this brings me to Plessy v. Ferguson. You will see this case cited in Brown v. Board of Education, and this is why I'm talking about this history. Is in Plessy v. Ferguson, you had in New Orleans, Louisiana, and Louisiana in particular, as well as many other states, the Separate Car Act. So many of you have been to New Orleans. They have a streetcar. Many places did at that time, actually. But they still do have a streetcar, but they were separate, meaning they had streetcars for black individuals, they had streetcars for white individuals. You could not ride on one or the other based on your race, right? So this is Jim Crow 101, but it wasn't called Jim Crow at this time, right? So this is actually Plessy. Excuse me. What do you guys notice about him? Mm,
Looks white.
bingo. That's exactly right. Now, there was a method to their madness. They chose him specifically because he did look white, because they wanted to test just how extreme this rule, this Separate Car Act, really was. So he was actually only 1/8 black. He looked white. And this is the interesting thing. So they actually had an activist group called the Citizens Committee of New Orleans, and they knew the railroad conductor, the streetcar conductor. And they had this plan to where when he entered the streetcar, that the conductor would say, what are you black or are you white? And of course, he would say, well, legally, I'm considered black. Because if you're even one drop, that was the term, one drop black, then you were considered black, right? And so that confirmed it for him. And he said, you cannot ride on the streetcar because it was a white only streetcar. And so, ding, 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 they had a case. That was their case. That was their test. Because in order to have a lawsuit, you have to have an injury. And that was his injury. He wasn't allowed on the streetcar, right? And that's a violation of equal protection of the 14th Amendment. So, what this Streetcar Act essentially did is it took the teeth out of the 14th Amendment because Plessy v. Ferguson confirmed, and listen to what I'm saying, it confirmed this Separate Car Act. It said it was completely okay. And it's kind of like, I was trying to think of an analogy to give y'all, and it's kind of like when you have, and I'm not getting to the bathroom argument. That's not what I'm getting at, guys. So please don't take it as that. But when you have a girl's restroom and a boy's restroom, it would be the argument that they're separate, but they're the same. They're equal, right? So it's okay that one goes to the other and one goes to the other, that they're separate but equal. That's the argument, right? And so, so the Supreme Court basically put a stamp of approval on the Separate Car Act and opened a very ugly door in our nation's history. And they said this wasn't a violation of the 14th Amendment. And so this is what allowed the steamroll of Jim Crow to roll throughout the South, which allowed, water fountains, movie theaters, restaurants, diners, you name it, hotels, right? Heart of Atlanta case, we all remember that one, to have segregation, to have blacks versus white facilities, right? This is the case that allowed this to become legal in the United States. So I want you to have that in your head. But I want you to pause for a second. The court in Plessy is interpreting the words in the Constitution. What gives them the ability to do this? Anybody?
Judicial Review
Yes, that's
from
exactly.
Marbury versus Madison.
Yes, yes. Okay, I am so pumped. That's exactly right. And Cassandra asked Creole. Yes, you hit it on the nail head, Cassandra. All right. So I just wanted to kind of make sure that you guys don't forget the previous case law and concepts that we've gone over as well. So Plessy opened this ugly door and it took the teeth out of the 14th Amendment as well as the Civil Rights Act of that time. So we had this infrastructure that was there and then we just let it crumble, right? Because now is somewhat meaningless at that point until Brown v. Board. Now, you might see this referred to if you guys look online for additional information about Brown v. Board. Sometimes it's referred to as Plessy Part 2 because it's dealing with somewhat the same issue, same concepts, and so it's known as Plessy Part 2, but it's Brown, right? So I'm just putting that out there just in case you see that. So this deals with little Linda Brown, and that's actually her in the picture that I included. I love this picture. I just think it's such a cool picture with her and her mom. But they live in Topeka, Kansas, and she lives from 7 blocks away from a school, only 7 blocks away from a school that she could easily walk to, but she can't go there because that school that's 7 blocks away is only for white children. She has to go instead 6 blocks away to board a bus to thereafter go a mile further to a school that's reserved only for African American children, right? Hence the Plessy part. Separate but quote unquote equal. So let me give you a little context about Mr. Brown, the Brown family, because this is really important. They were residents of Topeka, Kansas, but the dad, Oliver Brown, who was the named plaintiff in this case, he was only one of a dozen. So when you see Brown v. Board of Education, I don't want you to think it's just Linda Brown and her family. It's actually over a dozen different families from all over, right? So some of them were from Louisiana, some of them were from Alabama. They were from Topeka, Kansas. Okay, so I want you to remember that. Now Oliver Brown, he was awesome. Like he was just a good guy. He was a welder, World War II veteran. He served as an assistant pastor at his local church. I mean, you just can't find anything bad about Oliver, right? I mean, he was a great person. So I can't imagine doing this you'd have to be so brave, on many different levels, and your whole family would have to be brave. But they volunteered to be the test case for this from the NAACP. And he volunteered to walk his daughter to the all-white school that was 7 blocks away, the one that was closer to their home. And they knew, as a parent, especially during this time period, what you're putting your child, what you're putting them into, right? What they're going to face. But they did it nonetheless because they knew what they were trying to gain, the end goal, right? And so they went 7 blocks away. The principal turned them away. They had them wait in the waiting area for a significant amount of time. And the principal only came out to say, you can't go here. You have to leave. And they were kicked away. They were turned away, right? So that opened the door to an injury. Again, they needed that injury. In order to have a lawsuit, you have to have an injury, something to remedy, something to fix. And so that was like, boom, door open. Yay. I mean, not yay, but yay, right? And so now they have the basis to argue and they can consolidate these cases and bring forward this action. All right. So a couple things to note. Why do you think they chose Brown and not the others who were from more southern states? Because I mentioned there were others that were from Alabama, Louisiana. Why do you think they chose somebody from Topeka, Kansas?
It might be because his background.
You mean like who he was in terms of like a welder and a veteran?
Yes, the veteran part.
Absolutely. That definitely was a part of it, Billy. You're 100% right. But there's also an added layer to that.
It
So
was
take it one
not
step further.
not as
They were
hard.
part of the Union. Kansas was part of the Union.
And take it one step further, because
They
you're
were
almost there.
Maybe
were
like
part of
West
the
Side.
They were one of the states that came in after they had passed um, that new states, you get one slave state and one non-slave state.
You're overcomplicating it. Think about, and don't even think about slavery, non-slavery. Just think about social response. Think about that time period.
Kansas wasn't as racist as some of the southern states, basically.
So you guys are all almost
They
there.
weren't as affected by Reconstruction as the southern states.
You're all almost there. Again, you're like, y'all are like right on the edge of saying it, but not saying it. So they said later it was done because essentially, if they would have picked somebody, and y'all can read the bullet point, but I'll just explain it further. If they would have picked somebody from Louisiana or Alabama, the southern states would have been pissed. And I'm saying, I'm sorry for my language, but they would have been pissed. They would have felt like they were being picked on, and that it would have been the South against the elitist Supreme Court elite, right? And they didn't want that to happen. They didn't want it to look like the elites North against the South, the pure South. Because when you think of Southern states, then you automatically think of, and I say this in general, traditionally people think of Alabama, Louisiana, Mississippi as a traditional South.
American South. Yeah.
Correct.
How America
I
should
wouldn't
have
think,
was
I wouldn't
was
think
and
Kansas is South.
Correct. And so Kansas
She was right.
was the one that smacked the least south and would be the least controversial in terms of the named plaintiff. Again, if they would have picked somebody from Alabama, Alabama would be pissed because they would say, "Oh, there the elites are picking on us Southerners again." And so picking Oliver, that was done on purpose. And I am highlighting that because think about the strategy that goes into every single detail in these cases. They have to literally think about even who the named plaintiff is. So when we go through these cases, and you read these names, I want you to recognize that they're not just names. They actually thought about who was going to be that name. And there was a whole lot of debate about who that named plaintiff was. There was entire NAACP meetings for months as to who they were going to call out, because there was a whole faction of the NAACP at that time that said, no, we should call out the South. We should pick somebody from Alabama because they're the ones who are the worst. But then there's another fraction that said, no, we can't do that because it's not going to help our cause. We need to pick somebody from Kansas like Oliver because and as I forgot, I think it was you, Billy, who said his background, who he was, pastor, welder, veteran, just who he was as a person, but also geographically, it was the least controversial. It would, again, just as they noted, it would not smack of being a purely Southern issue, right?
I mean, the name itself, Brown, also kind of goes with like what you're talking about. It kind of works out too. Everything kind of fits. But
yeah, isn't that funny?
If a person has do they look at like the history of a person? Like I know you're saying his background, but do they look at like their entire family as a whole, or like even like the student, right? Who's the student that if they were like a troublemaking student, would that be like something like, well, maybe not them?
Oh, for sure. For sure. I mean, and especially for something this big of an issue, they strategize. I mean, they're not, for something this big, they are going to want the best of the best. And I mean that sincerely. I mean, there really was strategy from the top down to ensure that they would face the least amount of pushback based on their plaintiffs. And it stinks, right? Because even if the kid was, and a troublemaker, it shouldn't matter. But they wanted the least amount of pushback based on those issues as humanly possible. And so they found the Brown family were like a Folgers commercial, right? Like you couldn't find a better plaintiff to name than Oliver Brown and his family. They were amazing. So they really lucked out in terms of them, and they strategized. Again, there was a method to their madness. And now I'm looking through your chats, and let's see. Farrah said, if this is a federal case, why are they able to dismiss the complaints of other Southern plaintiffs just because they are from the South? Oh, no, no, they weren't dismissed. They didn't dismiss them, Farrah. They were included. They're just not named. So it's kind of like a class action. So you had the Brown family, and they're the represented named party, but within that are 12 other families who are from the South, who are from Alabama, Mississippi, the traditional Southern states. So they were just the named plaintiff. They weren't
Got
dismissed.
it. Makes sense. Okay.
But great question. I'm glad you asked that. Okay. So, all right. So I'm going to go forward a little bit. So this case is amazing for several reasons that I want to highlight. I hope you guys really take your time reading the decision because there's something that happened in this decision that had never happened before. And as you see in my second bullet point, they actually cite social science. And that may not seem like a big deal, but it is because it had never been done before. Just like last week when we touched on Trump v. Hawaii and how his tweets, President Trump's tweets were actually talked about, whether or not they should matter, whether or not they did matter. And think about that. That's crazy that we're now at a point where social media is impacting legal decisions, right? Or it could have. It was debated, right? So this is the point when social science, sociology, psychology open the door in terms of the Supreme Court considering, okay, we're dealing with this legal issue, but let's look at the humanity of this. What is the impact of separating kids by their race in the educational system? And based on the social science studies of that time, they found there was a significant emotional, psychological impact that children, African-American children, were suffering psychologically, being separated because they felt inferior, less than, they were given less resources, they were suffering in terms of their education. There's a whole host of negative impacts. And so that was taken into consideration. And that motivated the court to overturn Plessy. They said, look, separate is not equal. That's malarkey, right? That's the word of the day, guys. Malarkey. And so the cool thing is they put the teeth back into the 14th Amendment. They said separate is not equal, right? Equal protection. You got to have that in there. You cannot separate individuals based on race. That's a no-no, right? But here's kind of the bummer thing. The Supreme Court, they're smart cookies. I mean, that's why they sit on that bench. But the bummer thing is they use this phrasing in their decision. They said that it tasked local federal judges with making sure that school authorities integrated with all deliberate speed. Any issues with that, guys?
They can take their time and do it whenever they want to.
That's exactly right.
Excuse for why it's taking so long. The children are struggling with understanding how to do this, and the system is different, and we have to redo the boundary lines and blah, 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 and just find every reason of why it can't be done expeditiously.
Well, and to kind of highlight just how dragging of feet occurs, when I was associate city attorney in Tangipahoa Parish, Louisiana, we had a lawsuit, guys, and this was in 2013. I'm gonna say that again. 2013, in which the school district there was still arguing about integration. So, with that being said, that statement with all deliberate speed, it sucked because it was so vague. It gave no definitive timeline saying you have to within blah, 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 right? And so even today, 2026, there are still lawsuits regarding this and school districts complying, right? So it's still an issue. Yeah, wow and yikes is a good way to put that. When I first got the job and I got those pleadings, I sat at my desk and I was a young attorney at that time and I was just like, holy crap, like I was not prepared for that. And Billy said, we fight with ADA standards. Yeah, it's amazing. I mean, it's interesting. But the theme I want to implore to y'all is that these words matter, right? And even though Brown v. Board of Education is historic, it is monumental. That terminology with all deliberate speed has faced a lot of criticism, and rightfully so. So just take that as it may. But I did want to highlight one fun fact, like I always do, about this man. Does anybody know who this man is who has a sweet smile?
Thurgood Marshall.
Yes. Okay. So Thurgood Marshall, he was a character, and I just really enjoy him. So he was on the Warren Court, and he turned into the Rehnquist Court later. But what I love about him is that he had a really good sense of humor. And Supreme Court justices, especially Rehnquist, was like super serious. And so he was known for kind of gigging him and saying, like, what's shaking, chief, baby? And like just making people laugh. But I wanted to point out a couple other things about him that are noteworthy because this is the class to do that. I'm trying to move my face so that way I can do that. Okay, here we go. So he actually argued before he was Chief Justice, and the reason I'm bringing him up, he was the lawyer for the Brown family. So how cool is it that he was the lawyer that won for Brown v. Board of Education, and he later became a Supreme Court justice? That's pretty amazing. But he actually argued 32 cases before the Supreme Court, won 29. That's amazing. And this is just a really interesting side note. Initially, he was rejected from the University of Maryland Law School because of his race, and he later sued and won and earned his law degree. So just really cool fun fact about Thurgood Marshall. History is an interesting thing. Oh, and my favorite thing is he hated legal jargon. And so he actually would chastise his fellow justices when they would write these opinions, which used huge big words and long descriptions that drug out explanations. And he would always say, "Right for the common man." And I always thought that was such an important message that I hope and I wish that more justices followed. He said we should be writing for the common man so that they can understand the law too. And so he did. And if you ever read what he wrote, you'll note that he wrote in a very simple manner. So if you have time, yeah, you're right. Somebody said, thank God he had people like me in mind. But he really did. And if you go back and you read his writing style, that may actually help you with this week's writing, is to go back and look at the way he wrote and try to model his style. Just food for thought. Okay, so stop. You hopefully are wondering, why are we discussing Brown v. Board in relation to the topic or the issue of due process? At this juncture, I want to point out that there are actually two types of due process, but I don't want you to panic, okay? Don't panic. There's procedural due process and substantive due process. Now, you guys actually already know what procedural due process is, and we tackled it when we talked about Magna Carta. Procedural due process is two things. Notice, meaning the government has to tell you why they're about to take away your life, your liberty, your property. They can't just take it away. They have to tell you why, right? And secondly, you have to have an opportunity to be heard, meaning you have to have a chance to defend yourself in a trial, right? So that's procedural due process. You get notice and a trial. You get procedure, right? You get those two steps, those two procedures. But there's a second type of due process that is the theme, the reading rainbow, so to speak, of today. And that's substantive due process. Now, you know how the procedural due process says the government can't take away your life, liberty, okay, that word, that's where substantive due process comes from. Because isn't liberty a vague word? In my face-to-face classes, I always have students at this part of the class, I have them write down how they would define liberty. And it's so funny because typically I have classes of like 40 to 50 students, and I will get 40 to 50 different answers. It's amazing how varied of responses I get. And that really underscores how liberty is such an important concept that we all value. But in terms of what it is, it's not really defined, right? And that is where substantive due process comes in. So we have many substantive due process rights, like we have the right to marry, education, Brown v. Board of Education, right to have kiddos, and the right to make certain medical decisions. So let me put it another way. Are any of these in the United States Constitution? Like, is the right to marry in the Bill of Rights?
No.
The founders definitely did not include that. And if you know their histories, you know that they're like, no. So, with that being said, these are rights, substantive due process rights. And listen to what I'm saying, are rights that are not enumerated. They're not in the Bill of Rights, but nonetheless, there's something that are considered important to us. And by us, I mean our society, right? And so, because they're important, they become elevated and protected. But the $1 million question is, how do we figure out what is important? How do we figure out what should be protected, right? So, when we think is what exactly is a fundamental right, and again, I know many of you might feel like this, but I want to simplify it. I want you to think about again, there are certain rights that are not nowhere to be found in the United States Constitution. There's nowhere in there. So you remember there was that debate between the Federalists and the Anti-Federalists. And the Federalists were arguing, the Anti-Federalists are saying, look, if we write down all of our rights, then there's that fear that we might leave something out. And then the Anti-Federalists are saying, well, screw you. I want all of them written down because if we don't write them down, then you're going to run all over us. And then they came to a compromise, which was the Ninth Amendment. They said, look, the Ninth Amendment will save us because essentially it says just because we didn't write it down doesn't mean it doesn't exist. That's what the Ninth Amendment stands for, guys. Just because something wasn't written down doesn't mean it doesn't exist. So the Ninth Amendment, and let me show my face real quick. I want you guys to put on your imagination hats, right? So the Ninth Amendment, I want you to imagine that it's a bucket. And I sincerely mean that. Imagine it's a bucket. And the United States Supreme Court, because of their power of judicial review, they determine what goes in that bucket, meaning what becomes a right. Because it's nowhere in the other amendments, it's nowhere over here. What can become a protected right and fall in this bucket? Okay, so we've determined marriage. Boop, it goes in that bucket. Loving v. Virginia, right? And there's some other rights like education, Brown v. Board of Education. Boop, they throw that in that bucket, becomes protected. It's a liberty interest, right? That's substantive due process. So because it's not in Amendments 1 through 8, again, it doesn't mean it doesn't exist. The Supreme Court can determine that a right exists using the Ninth Amendment. So when you think about that liberty prong, that bucket is your liberty bucket. What goes in that liberty bucket? What is the Supreme Court going to protect? So we looked at Brown v. Board of Education. Education, again, goes in that bucket. It's protected now. Now we're going to look at a second case that looks at something to determine should we protect it, right? And I gave you a hint a second ago, but now we're just going to look at the actual case. And I love the name of this case. And it's funny because one of you had mentioned Brown v. Board of Education and the name being quite fitting, right? This name is quite fitting as well because Loving v. Virginia is about marriage and love. And isn't it great that it's called Loving? I mean, you can't get much better than that, right? So let me move my face so you can see this lovely couple. So we're dealing with a couple, Black woman, white man, 1960s, right? Not a great time to be an interracial couple. And I included this link. If you actually want to see interviews with them, you can click on this link. They did a massive amount of interviews and they're fantastic. There's also a documentary that came out, I believe maybe like last year-ish, that's really good as well. So I highly recommend if you're interested to watch it because it's really good. Oh, and oh, that's so neat. The state slogan for Virginia is for lovers. Yes, that's awesome. And Billy said there's a movie. Maybe that's what I'm thinking of, Billy. I'm thinking maybe of the movie. But either way, this is a great link if you're interested. But their names were Mildred and Richard. I love that name, Mildred. That's such a great name. But they are expecting a baby and they get married. And so they're happy campers. However, they have to get married in the District of Columbia. And they return back home to their home state of Virginia. Why? Well, they had to leave because Virginia had, at the time, what's called anti-miscegenation statute. Anti-miscegenation is basically an interracial marriage statute, meaning it banned interracial marriages. So they were literally banned from getting married in Virginia at that time. So they had to hop in their car, drive to the District of Columbia, get married, and then drive back to their home state. Now, when they came back, like many small towns that they were living in, word spread. Oh my God, Mildred and Richard got married. Clutch your pearls, right? And the word spread like wildfire. The local sheriff became obsessed with catching them, right? And arresting them for violating the anti-miscegenation statute. Now, he did something really awful, which is he purposely raided them in the middle of the night. And he said that he did that because he wanted to catch them in the act, right? Awful. So he raided their home in the middle of the night. They were actually sleeping. I mean, they're married, right? So, to catch them, and he arrested them for violating the Racial Integrity Act. And they actually were found guilty and sentenced to a year in jail. Now, the trial judge at the time, he actually agreed to suspend the sentence if they would leave the state and not return for 25 years. Now, I really want to emphasize just how crazy that is. Can you imagine you've grown up your whole life in one town? Your friends are there, your family's there, you are about to have a child, you want to raise your child around your family, where you grew up, and you're being forced to leave, and they're telling you you can't come back. I mean, that's a big deal. Now, at the time, the whatchamacallit, they were living in DC, they moved, and Mildred, poor Mildred, she hated it. There's letters actually in the National Archives from Mildred that she wrote to her family, and they're heartbreaking because she says, I want to go home. I don't like it here. I don't know anybody. I don't have any friends. Nobody will talk to us. People just stare at us. So they were miserable. And so at the time, though, the judge, and this is actually in the transcript and the opinion, he actually said, Almighty God created the races and he placed them on separate continents. The fact he separated the races shows that he did not intend for the races to mix. Yikes, right? So that's what they're facing at this time. Now, Mildred did something pretty cool. She was so upset that she actually wrote a letter to the then Attorney General, Robert Kennedy. Now, remember, his brother was president at the time. He hadn't been shot yet. And he read the letter and he was so moved by their experience that he passed the issue along to the ACLU. And he said, look, you guys have got to represent them. This has got to be pushed up because this is a big deal. And the major issue that I want you guys to have in your head is, one, marriage is not a constitutional right. It's not in the First Amendment, Second, Third, Fourth, Fifth, Sixth, Seventh, Eighth. So we're not dealing with something that Mildred can say, I have a right to this. No, she doesn't. No, he doesn't. They don't, because it's not an enumerated right. So we're looking at that bucket. Remember that Ninth Amendment bucket? They're looking at, does our right to get married belong in this Ninth Amendment bucket? Did the law violate this anti-miscegenation law, the 14th Amendment's Equal Protection Clause? And if so, should it be protected, right? Does it belong there in that bucket? So I want to highlight too the fact that this took 9 years. So poor Mildred and her husband, they had to live away from their family for 9 years while this all trespassed. I mean, this is a long time. Now, ultimately, it became a unanimous decision. It was a Warren court decision, and Warren wrote the opinion. So when you're reading it, just note that. And ultimately, they ruled that Virginia's act went against the Due Process Clause and Equal Protection Clause of the 14th Amendment, right? So they said the 14th requires freedom of choice, not to be restricted by invidious racial discrimination. And the right to marry resides in individual, no legit purpose other than discrimination. Now, what's interesting is this kind of like Brown v. Board of Education, with all deliberate due speed or whatnot. This actually stayed in the books in a lot of states for a long time. There were anti-miscegenation statutes in the books, even in Alabama, up until 2000. So it took quite a long time for states to officially get rid of these statutes. But it's important to note that both due process types, procedural and substantive, were touched upon in this case. You have procedural because they put in this anti-miscegenation statute, took away their right to marry without telling them why and without giving them a chance to defend themselves. So that act was put in place before they even had the chance to get married, right? So that's procedural. But the second prong, of substantive due process is marriage. It's not in the amendments, it's not an enumerated right, but the court ultimately found it was a fundamental one. It's a liberty interest that should be protected. And so it was thrown into that beautiful Ninth Amendment bucket and became protected. So we have this protected right to marriage as a result of loving. So kind of a fitting, wonderful, beautiful conclusion of a case with the most perfect name ever. So that is the first substantive due process case that I want you guys to have in your minds is that marriage, right? Marriage prong. The second case that you guys are tasked with reading this week is Griswold. So Griswold looks at another issue as to whether it belongs in that substantive due process bucket. And here we're dealing, again, this couple was married. So we're dealing with another married couple. And there was a ban on contraceptives in Connecticut. And listen to this law. This is cuckoo. It actually was put in the books in 1879, and it provided any person who uses any drug, medicinal article, or instrument for the purposes of preventing conception shall be fined not less than $40 or imprisoned not less than 60 days. Holy cow, right? Pretty extreme. So they sued and they said, we have the right to use contraceptives. So the million-dollar question here is, do they have the right to utilize contraception? Since privacy expectation within marriage, is this something that falls into that liberty prong that falls into the Ninth Amendment bucket? Is this a violation of marital privacy? Well, remember, there's that great Ninth Amendment bucket. Just because it's not written down doesn't mean it doesn't exist. Now, there's something that came out of this case that you're going to see. And, well, Billy asked who would know. Well, they have to buy it, right? They have to get it. And so if they are prevented from getting it, that's an injury. And so that's where the case comes in. And let's see. Oh, I didn't know that. And somebody said, and now Loving Day exists in light of them to celebrate all interracial marriages and relationships. I did not know that day existed. Thank you for telling us that. That's really cool. That's very, very neat. Thank you for sharing that. So Justice Douglas, you know how I hate legal jargon, guys? I'm very much like Thurgood Marshall in that way. And that I really, it's like the bane of my existence. I hate when people overcomplicate things. And Justice Douglas did that. So he created this word. Well, he didn't create the word, but he adopted the word, I should say, to explain creating a right that is not within the Bill of Rights. So I've been telling y'all, I've been beating y'all over the head saying if a right doesn't exist, that doesn't mean that it's not protected, right? Just because it's not written down doesn't mean it doesn't exist. Justice Douglas had to overcomplicate it, and he said that's a penumbra, right? That we can have a penumbra based on the rights that are in the Bill of Rights. I know, you probably feel like that, right? I still feel like that to this day. It's awful. So let me try to simplify this. So what a penumbra is is an implied power. What he's doing is he's looking at the First Amendment. He's looking at well, not so much the Third Amendment, because that's the quartering of troops, right? But he's looking at the First, he's looking at the Fourth Amendment, he's looking mainly at the Fifth Amendment, and he's saying,
Sorry, no, I'm just taking training. Let me pause it.
based on the spirit of these amendments, he's saying that based on these, that we have a spirit of privacy. And that's true. If you look at especially the Fourth Amendment, it beats everybody over the head saying the government can't enter your privacy bubble without probable cause, right? They have to have a pretty darn good reason for invading your private space. And based on the Fifth Amendment, the government can't force you to talk, to self-incriminate, right? And so there are these pockets throughout the amendments that imply again and again and again that we have privacy. And that's what Justice Douglas is saying, is that we have these implied rights, that even though it may not say that we have a right to privacy within a marriage, that with all taken in consideration, these other amendments, we do, right? So it's implied. That's what a penumbra is. A penumbra is implied. Okay, that's what that means. And I'm sorry that he used such a complicated phrase, because to me, that's awful. But that's what he's saying. So based off of that, the Supreme Court said, yes, you absolutely have the right to privacy and to use contraceptives because you have the right to privacy based on all of these rights. So here's the Ninth Amendment bucket. And what did they do? They just added to it. So they said, you have the right to privacy in your marriage and you can use contraceptives. Boop. So that goes into the bucket too. So far we have education. Boop. We have what else? What other things go into the bucket so far?
Interracial marriage.
Good. Marriage.
Marriage and education.
Good. Marriage, education, contraceptive, right? So we're filling up that bucket, guys. It's getting fuller, right? But then we come to Washington v. Glucksberg. Little different. And I really want your ears to perk up. And I know we're going a little bit over, and I'm so sorry. Don't be mad at me. I'm trying. But Washington v. Glucksberg. So here we're dealing with 4 patients who, unfortunately, they're terminally ill. There's just no path to recovery for them, right? Very sad. And so they discuss with their physician about physician-assisted suicide, okay? Because they don't want to wait it out. They want to, based on their decision with their physician, come to a course that ends their pain and suffering. And so they are faced with a roadblock, though. Washington, where they're located, has a strict ban against such assistance. It says, no go. You can't die by suicide with the assistance of your physician. That's a no-go. But does this ban violate the 14th Amendment? In other words, you have the right to life, liberty, or property with due process of law. Can the government take away your ability to die by suicide without telling you why and without giving you a chance to defend yourself? And is that, or conversely, is that a substantive due process right? Is death by suicide something that should be in that Ninth Amendment bucket, right? So that's essentially what the Supreme Court is facing. And let me see your chats. Let's see. Okay, I remember this case. And then Lisa said, I feel we should all have a right to assisted in death if you're terminally ill. And a lot of people felt the same way. This is a big case when it first came down. It made quite a lot of waves when it came down. So again, you have the right to life, liberty, and property. Just remember that. Now we're dealing with a different court. So in the past, all the other cases that we looked at were the Warren Court. And the Warren Court, I mean, they were an explosion of rights. It's like, and again, I'm dating myself, but it was like Oprah, like, you get rights, you get rights, you get rights, everybody gets rights, right? Like they went right crazy, right? Rehnquist is a little different. Rehnquist is like, pump the brakes. Let's think about this. They weren't as free-handed with the rights as the Warren Court. And so when the Rehnquist court looked at this, they said, wait a minute, what are we guaranteed to? What is the exact wording? Well, we're guaranteed to life, not death. It doesn't say you're guaranteed to death, liberty, and property. It says you're guaranteed to life, liberty, and property. And so they read it extremely literally. So you could say that Rehnquist in particular was a strict constructionist. He read the words as they were written, and he did not want to interpret outside the literal wording that was within the Constitution. And so that was his justification, was that the literal wording of the Constitution negated this becoming a right, a recognized right, as a substantive due process right. So that was not added to the Ninth Amendment bucket. Okay, so that was not added. So the next one that we'll tackle two, are the big heavy hitter cases. But I did want to bring to your attention, I got a couple emails asking if I could recommend any books or websites, and the answer is yes. This book is amazing. I highly, highly recommend it if you are interested in the context of Roe v. Wade, because Justice Blackmun, of course, wrote the opinion of Roe v. Wade. And, excuse me, if you're wondering about how he came to that decision, this book is actually his diary. Now, when he died, there was this ban on anybody publishing his diary account for, I think it was like 25 years. And then that, time span passed, and then they were able to publish them. And so you're actually reading his actual thoughts going into it. So this is like gold for anybody who loves law. And I don't care if you're, how you feel about Roe v. Wade. And I mean that literally. It's just fascinating to be able to see the mindset of a justice who is actually going through one of the most historic cases in Supreme Court history, right? So if you're interested in that, that's one really good book that I highly recommend. But let's just go into Roe v. Wade. So Roe v. Wade, of course, deals with a woman who sought an abortion in Texas. Now, abortion wasn't banned 100%. It's important to note it did have exceptions. At the time, it had an exception for rape and incest. But at the time, they felt like that wasn't present. And so her procedure was ultimately denied, right? But here's an interesting side note, which is really rare. She actually had given birth by the time the case reached the Supreme Court. And you remember how I said that typically cases have to have an injury that can be resolved, right? That they can be fixed. And so there was a debate at the time as to, well, she already had the baby, so how are we going to fix this? There's no injury anymore. But they resolved that by saying, look, well, she could get pregnant again, and this could be an issue again. So that's how that was handled, if anybody, is interested in that aspect. Now, the attorney, Wade, district attorney, he argued on a few grounds. So Roe argued initially that a constitutional based argument that abortion is a guaranteed right, and the district court sides with her under the first because they found that this was basically a religious basis of ban, because everything that the DA had initially argued was First Amendment based. It was religious based. And of course, you have the Establishment Clause. The government cannot require or incorporate religious doctrine into law. That's a no-no, right? They can't force us again, like tomorrow, for everybody to be Scientologists, right? Can't do that. You have to have a separation between church and state. And so because of that, the district court said that's a no-no, right? Excuse me. So the question was, is it a state matter? There's nothing about it in the Constitution, so it's up to the states, right? 10th Amendment? Or are we saying that this is a right that should be protected under the 9th Amendment? Is it something that goes in that 9th Amendment bucket? So with that in mind, Floyd, and I really hope you guys look this up, because if you go on OEA and you look at the oral argument and you listen to it, he's known to have told the worst joke by any attorney, which, God, that'd be a horrible thing to be known for. But the worst joke in all Supreme Court history, which is, he said, whenever a gentleman argues against two beautiful ladies, they'll always get the last word. And apparently, and again, we don't see the video because there's no video inside the Supreme Court, But apparently everybody was just staring daggers at him, like hated his joke. You can hear the crickets in the room. I mean, it's bad. It fell very, very flat, just a very poor taste. But nonetheless, that kind of set the tone, right? But Blackmun, Justice Blackmun, he had to look at two things, which is, okay, why? Why do they have this restriction on abortion? Meaning, why do they limit it to rape or incest, right? As the exceptions? Why? What is their rationale? And the reason that the state gave was health, for the health of the woman and to protect the fetus, right? But Blackmun, he actually went to hospitals. He went and talked to doctors with the other justices, and they looked at this as a medical decision by a doctor, and they looked at the trimesters. And this is where the trimester rule started. And I want to emphasize the year this came out, okay? This is many, many years ago. But they said, look, an abortion during the first trimester is safe. So there's no compelling interest to protect the woman or fetus during this time period because the procedure during the first trimester is, again, safe for the woman. And excuse me, the fetus isn't viable during the first trimester. So that isn't a rationale that holds much water for us, the court. So what's your next, right? So then the state says, well, what about the second trimester? And they say once the second trimester starts, there may be an interest in regulating for the health. And by the third trimester, the fetus can survive outside the womb. So there may be an ability to regulate abortion at this point. So Roe v. Wade, it wasn't an open door to abortion at any and all points of a pregnancy. It was based on trimester, and it did allow for regulation of abortions. Now, remember Griswold, the case that we went over, and it said that there's that zone of privacy, that penumbra? That is the case that Roe v. Wade used in support of this decision. But here is the kicker, and I really want everybody's ears to perk up when I say this. Roe v. Wade was known as a woman's rights case, right? Woman's rights case to choose. However, that's not the decision. The decision, and this is really interesting, was a doctor's right. It was the ability, that zone of privacy. Remember how Griswold said there was that marital privacy? Roe v. Wade was based on your medical privacy, meaning your decision with your doctor, a doctor's right to guide his or her, the doctor's patient based on that private consultation, that private conversation. And so I just want to emphasize that because that's often overlooked in this decision. But it was based on that Griswold concept of a penumbra of rights, of that privacy interest. And then, of course, we have Dobbs, which was monumental in terms of its impact, its response socially. I think we all, anybody who's interested in the law, probably, yeah. I see I have a hand.
One question that I have, did I read this correctly, Dr. Shaw, that in the Roe case, that at one time Blackmun had worked at the Mayo Clinic doing research around a younger time in his career?
They worked at, well, I know he did research at the Mayo Clinic. So correct. He did do research at the Mayo Clinic and he did his homework for sure.
Which is what the reason I bring that up is it seems like that's where he landed on the doctor's right to have private guidance to his or her patients.
Perhaps. That definitely is what he emphasized. Absolutely.
Okay, thank you.
Yeah, good observation. Yeah, and again, I'm really glad you brought that up because again, in that book, Becoming Blackmun, he goes more in depth on that in terms of the research that was done and how he focused more on the medical right to choose, that medical consultation and the privacy that goes into that. When you go to your doctor and you have these conversations, there's an expectation of privacy. And so that is really what he hinges on. And so now we're taking it a step further into Dobbs. Now, Dobbs, of course, again, sucked the life out of legal analysis for a while because it, again, had such a profound impact. But I want to take it step by step together, okay? So first and foremost, Alito wrote the opinion, and it's 79 pages. All right, it's a long one. But he started out by saying that abortion presents a profound moral issue on which Americans hold sharply conflicting views, which I think is the understatement of the century. All right. But he emphasizes a few interesting points. He emphasizes that the Constitution doesn't refer to abortion at all. But again, one of the things that we've discussed today is there are a lot of rights that the Constitution has not emphasized or even mentioned, like marriage, like education, like contraceptives. So it's interesting that he touches on that because he again visits that later on with Thomas and Kavanaugh. So I just want to touch on that because there is a method to his madness and even bringing that up. So he isn't just randomly bringing that up. He's touching on the fact that this is a substantive due process right. He's recognizing that, okay? But he's arguing and he's emphasizing it's not in there. It's not in the Constitution, right? And then he points out that it's not deeply rooted in our nation's history. Okay, until the second half of the 20th century, Alito observed, there's no support in U.S. law for the right to an abortion. Indeed, he pointed out most states regard abortion as a crime. So now he's emphasizing that socially, historically, based on the briefs that he was presented with, that it wasn't a protected liberty interest. Okay, you see what he's doing here? He's building a case against abortion being a liberty interest. This is what he's doing. Okay, so this is the case that he's building in his opinion. And now he's taking it a step further. So the argument that many people initially made was, look, there's no way that they can overturn Roe v. Wade. Roe v. Wade, it is part and parcel to our Supreme Court history, right? Kind of like Brown v. Board of Education. But then he kind of turns it on its head and he says, well, look, Brown v. Board actually overruled Plessy, and Plessy was once a Supreme Court decision. So you can't tell me that the Supreme Court has never overturned its own decisions because we've been there and we've done that. So now he's knocking down that argument that people have made against overturning Roe, right? And I heard
So he's setting up that it is in fact fine for the court to overrule 50 years of precedent because Plessy was wrong and proven later that it was separate but equal was not right under the Warren Court.
That's exactly right. That's exactly what he's doing. So, and it's really interesting because, if y'all remember, right before this opinion came out, it had been leaked, right? And so there was like a massive upheaval in the legal world where scholars were just like, oh my God, you can't overturn this because this is kind of like women's right to
Yes,
choose
I
that
just need
equal.
to add
That is,
the
hold on.
infographic and I'm going to send
Can
it back.
y'all-
We're done.
Hold on, let me mute that. Okay. So they were equating it to Brown v. Board. So there's arguments saying, look, Brown v. Board is a part and parcel of who we are as a country. And then he actually took that a step further. He said, oh, you're mentioning Brown v. Board? Okay, cool. Brown v. Board actually did overrule another Supreme Court case called Plessy. So again, it's interesting how he kind of turned that argument on its head. Now, and this is where a lot of the debate lies, is they technically did not say abortion is banned. They did not say that it is overturned and that it's not illegal federally. What they did was they turned to the 10th Amendment and they said, look, we're going to kick it back to the states. Okay, so we're no longer going to say that it is, whoops, sorry about that, that it's federally, there's a federal protection to that right. Instead, we're going to say it's up to the states to decide. Okay, but in essence, that is essentially what it did do, right? And that's where Justice Roberts comes in. And this is fascinating, guys, because Justice Roberts, he's had some surprise opinions since he's gotten on the court, right? He's decided in ways that many were surprised with. And this is one of them. Now, he concurred, which pop quiz, what does a concurrence mean?
Goes along with.
Right, but
but has a different point that they want to make.
Good, good,
Um,
excellent. So he agrees with the ultimate conclusion, but thinks they could have done something a little different, right? And so Justice Roberts, he starts out his concurrence saying this is a serious jolt to the legal system. And he says, look, I agree to uphold the Mississippi law, but I would do so without overruling Roe. Now, he also mentions Casey as well, but for your purposes, you can just focus on Roe. Now, he points to the viability standard that Blackmun created. Remember the trimester rule? And he said, yeah, that presents a dilemma because now we're at that time, 2022. He said, we're in 2022, medical standards have changed. Fetuses are able to survive outside the womb at much earlier times. So maybe we should revisit that, right? But he said the right to terminate a pregnancy should extend far enough to ensure a reasonable opportunity to choose, but not extend any further. And he wrote, ultimately, the right to reject abortion at all should be left essentially for another day. So, in other words, he's acknowledging the fact that the majority opinion is having the result of having a ban type effect on abortion throughout the country, even though the majority is saying that they're not doing that, that they're just kicking it back to the states. But Roberts recognizes the effect that the majority opinion will and did have. Now, Justice Kavanaugh Thomas come out with something really interesting, and I'll answer your questions in just 1 second. I just want to get through this one point because it's extremely important, especially in light of our conversation today. So Kavanaugh Thomas wrote concurring opinions as well, and Kavanaugh, that's why I put K. He wrote, does not outlaw abortion throughout the United States, but instead properly leaves the question of abortion for the people and their representatives. So his is not so much a concurrence. I see his as more of he is underlining the majority's position. He's saying, this is what we did. Underline, highlight. That we didn't do what everybody thinks that we did. That's essentially what he's saying, right? Thomas did something very different. Now, Thomas indicated, at least for him, decisions like Griswold, Lawrence, Obergefell are very much in doubt. He reiterated his view that the Constitution's due process clause only protects process. Okay, so let me put that another way. He wrote, it does not protect any substantive rights. In fact, he urged the court should reject substantive due process entirely. So all the cases that we've talked about today, like Brown, like Loving, like Griswold, all of those, he is saying that they should, but if you notice, he leaves out Loving in his list. He
well,
lists
that's because he's
Griswold.
married to a white woman.
That's exactly right. And that's something to consider. And I'm not saying that in a political way, guys, because I'm not getting into the political front of that. But it is interesting in that he left out Loving out of his list because Loving is the one case that deals with interracial marriage, and he is married to a white woman. So that is just an interesting side note. But he is advocating for that. So that is not what the case did. But note how in the very beginning of this term, I mentioned that you can kind of see where a court may go in the future by their concurring and dissenting opinions. Because these people are going to be on the court for a long time, right? And Thomas has already been on the court for a significant amount of time. But notice that this is now something that's been talked about. So I'm not saying it's right. I'm not saying it's wrong. But what I am saying is that it's a thought. And so just consider that all the cases that we've talked about today are something that's being talked about as being advocated to be overturned, meaning substantive due process is something that Thomas at least feels like shouldn't even exist. So that's a really interesting side note in terms of our whole theme today, which is substantive due process. Now, in terms of the dissent, and this is really noteworthy, they point to Kavanaugh's argument that the decision was neutral since it was leaving it up to the states. And they argue that the court, they said, does not act neutrally when it leaves everything up to the states. Rather, the court acts neutrally when it protects the rights against all comers. Kavanaugh's position, they insisted, was instead a no compromise refusal to recognize a woman's right to choose. Now, Anybody notice what is missing from their closing statement, which is the first time in United States history it has not been included? Okay, it
Where
is
it says what's being held.
respectfully.
Okay.
Yeah, respectfully. That's the first time in United States history that the dissent left that off. And so that should tell you what the climate is on that bench right now, between the justices. So it's just an interesting side note, that I wanted to point out. And then this, my friends, is for you guys. So happy birthday or early Christmas or whatever. If you guys are evaluating a substantive due process issue, that's what SDP stands for. Some things to look for is, when you're determining whether or not something is a liberty right, whether or not belongs in that Ninth Amendment bucket, is there a case that's touched on that before? So you guys look and you're running list of cases that I hope again that you guys are keeping. So did Loving touch on it? Did Griswold touch on it? Excuse me, did Brown touch on it? Then is there something under the 14th Amendment that might support whatever it is that you're looking at being protected? Is there a historical basis that supports it being recognized? Have we been doing something for a long time in our country? And as a result, it should be protected because it's something that's so ingrained within our social practice, right? Is this something that should be considered an individual right? These are considerations for you to think about as you tackle this week's assignment for week 5. And then, interesting. Ignacio says, Sotomayor said with profound regret in Trump v. Hawaii. Yeah, that's that. I mean, you can tell a lot by how the justices feel in those little verbal or in those cues, especially in the dissents. Okay, so tag you're it. What questions do you have? And thank you for letting me talk so long, guys. I'm sorry. I tried to get done in time, but I failed miserably.
I think you covered, for me this time, the importance of the observation of the concurring opinions.
Mhm.
I had started to notice that last week when we had the case where the court said, well, that's a non-justiciable manner, that because the Senate has the sole right to trial.
Yep.
And if you read in that Justice Souter's concurring opinion where he said he supports it, but if the Senate misbehaves, there would be an opportunity for judicial stepping in,
Yeah,
right?
absolutely.
So
Yeah, right.
that starts to set up the kinds of things that you were talking about today, which is the moves over time and the number of cases that were sent to the Supreme Court about Roe v. Wade and the little opinions written along the way that ultimately came out in Alito's opinion that there was no constitutional right here.
Mm-hmm. Yeah, isn't it interesting? I
Yeah.
mean, it's fascinating how these things play out. And there, again, there's a context, there's a history to it. And we see these cases and we think of them as these like frozen points in time. But many of these cases are built on the backs of, hundreds, if not thousands, of different cases. And so there's a lot that goes into them and personalities, right? I mean, there's that to be said too. All right. And I see I have another hand up, but I have a lot of, I'm trying to see who it is. Let's see. Who is it? Oh, Griselda?
Wait, early, like you did mention that like government can incorporate religion into law, and it's one thing, kind of a theme that I've noticed, and I've always kind of had a question about this, is especially like now with the Roe versus Wade and all these decisions, you kind of see the politicians always talking about like kind of incorporating their religion on why they're making these decisions. And a lot of them, they are attorneys, so I'm very confused on how do they do that and why, because I always think like this should be separation of church and state.
Mhm.
But it's almost I can't turn on the news or hear any elected official without them kind of trying to push that. So how, if you can clarify that, especially when they're making these decisions, how is that and why does that happen? I mean, how do they?
No, that's a wonderful question. So it's a blurry line, right? And you're raising a valid question, but remember the First Amendment has two prongs in terms of the religious aspect. You have the Establishment Clause, which is what you're talking about, which is separation between church and state, right? Which prevents arguably the government from saying again tomorrow that everybody's going to be Scientologists. They can't arguably force us to engage in or practice any specific religious connotation practice, right? But what's that other religious prong? Anybody? See
It's
it in
like
the
even
chat.
separations of the schools and the races. I'm like, a lot of them seem to push that it's, the countries separated. I don't get that whole.
No, you're not wrong, but then there's that other or freedom of expression, right? So it's that you be you clause. So when you hear the politicians on TV or on floor debates espousing their religious beliefs, they have the right to do that, right? Just like you and I have the right to say, I believe in, again, flying church spaghetti monster in the sky, right? We have the right to espouse whatever religious beliefs that we want. Now, where it becomes muddled in terms of what you're touching on is if that religious basis is the sole justification for a law or policy. That is what you're talking about. And it depends. It depends on what the law is and what the policy is and what the given justification was. And, again, there are several recent state examples that muddle that line that have yet to be addressed. And so I can't really say, again, I don't want to give my personal opinion because my personal opinion doesn't matter, but legally, the courts have found that if there's a religious connotation, like in Roe, like what Blackmun had pointed out, that it's a no-go. You have to have some rationale that is not associated with that, because if so, then it does violate the Establishment Clause. But if you're just some politician going around saying, and I'm going to give an example, you might hear a politician say that they believe in the right to life because as soon as, a person becomes pregnant, that life is a life, right? And blah, 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 and fill in the blanks, right? They have the right to say that all day and night. They can go on about that as much as they want. But the $1 million question is there justification in whatever law or policy that they're putting forward? Is it solely based on that, or are they advancing something else? Does that make sense?
I think yeah, I just kind of think like more of my question is that a lot of it seems to be back to the separating of the races at schools. That a lot of these laws are they have the right to say that, but then we have a lot of policies in place and laws in place that seems that to be driven based off of somebody's religious views when it should have never been, and back to even their decisions where it says, I mean, like I said, I don't have that true language, but that's where I get confused. I'm like, they have the right to say it, but then when it comes into action of God said we should separate the races, and then we have Jim Crow laws, and we still see those actions today. That's where I get confused about that.
No, I mean,
you're probably not a question to be answered today, but that's
well, no, I think you're making valid points though. Nothing happens in a vacuum. And so I think what you're pointing out is that these policies, these regulations, they are the products of personalities. They're the products of individuals, and individuals are human, and they're based off of whatever belief system that they have. And whether that's right or wrong, right? And so those belief systems have consequences, and we've seen that for a long time. And I'll give you some sunshine though, is that when those belief systems violate the law and they make it to the legal system, then the judges have the ability to serve, hopefully, their role as neutral arbitrators and address it. And if it violates the law, then they can address it and find that remedy, which is if it does violate it, they can overturn it. If it does violate a constitutional right, then they can address it, knock it down, interpret it as such. So that is the sunshine. But the $1 million question is, does it reach that point, right? And then the answer is sometimes. So I understand what you're saying, and you're not wrong. But there's no easy answer to that, unfortunately.
Okay. Thank you.
Yeah, absolutely. And I'll say, here is her last closing statement from her dissent. Our Constitution demands and our country deserves a judiciary willing to hold the coordinate branches to account when they defy our most sacred legal, because the courts with profound regret, I dissent. Interesting. Thank you for sharing that. And absolutely, Chris, no worries. No worries. Any other questions, guys? Yeah, for about I have about 10 maybe 10 minutes because I have another meeting right after this. So I'll definitely, can you call my phone?
Yes,
It
is
might
it
be
the number that you have listed in the introduction?
Yes, I'll put it right
Okay.
here too, just in case.
Okay.
Here we go.
Yeah. As soon as you leave here, I'll call you.
Okay, perfect. Perfect. Okay, guys. Well, I'm gonna hop off, but if you guys have any questions, let me know. I'm happy to help. And I just want to emphasize, I know substantive due process, fundamental rights can be overwhelming, but again, keep it simple. That's the theme. And just think about, does it belong in that Ninth Amendment bucket? And if it does belong in that Ninth Amendment bucket, why? Okay? All right. So with that being said, y'all have a great day, and I will see y'all next week. All right. Bye.
Thank you.
Thank you.